Hello, I'm Renee Boston. I am one of the birth injury and medical malpractice attorneys practicing law in Maryland, in the state of Maryland. As you can see behind me, I'm not in Maryland today. We're actually at a continuing legal education conference in the beautiful Montego Bay, Jamaica. But I want to take a quick break to talk to you about a question that I was asked recently, and that is, what exactly is a trial? Is a trial going to be like it is on TV? Or, how can I prepare myself for a trial? And with this video, I just want to give you like a quick snapshot as to what a trial is. So we're gonna presuppose that everything that was done to get the case from initial intake all the way through the depositions and discovery and all that stuff, we're going to presuppose all that stuff was done properly and correctly, and now you're into trial. So with trial, the first thing you need to know is that how it usually works is on day one, the judge will have all the parties into the courtroom and then ask if there are any preliminary matters. And at that point, either both sides, or if any side has any preliminary motions, they'll address them with the court at that time, whether it's any motions in limine, motions for summary judgment, anything that can be or needs to be litigated prior to the start of the trial, that is done at that point in time. So once the motions or any preliminary matters have been addressed and dealt with, that part of the incident is over, and then the next step would be jury selection. Now, how it usually works in most of the jurisdictions that we practice in regularly is there's a huge jury pool. And these are people who are vote or drive in your particular jurisdiction, and these people are called in, they meet up, and they're in one big jury room at the beginning of the morning, and then they start to be separated into smaller groups going into the various courtrooms. Now, these people are brought in and they're asked questions through a process called voir dire. And with voir dire is a question and answer session between the attorneys, both and for this case, we're going to talk about a civil case. So the plaintiff's attorney as well as the defense attorney are going to ask questions of the prospective jurors. Either they have a list of questions they have already prepared and given to the judge, or some jurisdictions, the attorneys ask the questions themselves directly. And during these questions, the attorneys attempt to elicit information about each prospective juror to learn more about him or her. So let's say, for instance, this is a case involving a surgical error issue. So your attorney may ask questions, or both attorneys may ask questions about whether or not you or somebody you know or love have been a victim or have had complications following the surgery. So the attorneys will ask questions like that to determine whether or not there are any preconceived notions or ideas prior to appointing this person to the jury. So once the voir dire process is completed, both sides will go back and forth, and we'll go through the prospective smaller jury pool and pick the set amount of jurors. And the judge will tell you how many jurors are going to be allowed per case, and also how many alternates, just in case the trial goes for a few days or a couple of weeks, and the judge will let you know how many people are actually going to be involved in that. Okay, so that process is done. And the next process is when the case actually opens itself. So the plaintiff's attorney will get to make an opening statement, the defense counsel will get to make an opening statement, and once those opening statements are completed, then the examination process will begin. Plaintiff's attorney will ask questions of their witnesses, and that's called direct examination. Direct examination, just quickly, is when you ask your witnesses the questions that you want to ask him or her. When that part is done, the defense counsel gets to come up and ask questions of the plaintiff's witnesses, and that is called cross-examination. Cross-examination is when you get to ask questions of the other side. So you have direct, you have cross, and then once the plaintiff's case is concluded, he or she will rest, and the defense will get an opportunity to do their case. They'll start calling their witnesses, and then the plaintiff's attorney will get to cross-examine those witnesses. Now, once everything's completed, both sides will give closing statements or closing arguments, and at the end, the judge will direct the jury on what law to use in order to come up with a verdict on the case. So that is like a brief snapshot as to what the trial process is. Now, this is just brief general information about a trial snapshot in general, and specifically in Maryland, how it looks. And like I said, it really depends on the judge, the courtroom, and the jurisdiction, because throughout Maryland, the process may be a little different in certain places as well. But if you have specific questions in your state, in your jurisdiction, about your specific case, you need to talk to your attorney that you have about what the process will be like for you. All right, that's going to be it for today's quick educational video. I am Renee Boston. I am one of the birth injury and medical malpractice attorneys practicing law in the state of Maryland. We will see you next time. Guys, thank you for watching, and we will see you later.